Hey everyone, today we are going to revise Indian Contract Act Unit 1, that is Contract of Indemnity and Guarantee, from directly our ICAI module. So without any further ado, let's begin. Here I have prepared a flow chart using the same topics which are available in the ICAI module. This helps us to have the key pointers at glance. So let us start with the very first topic, that is contract of indemnity. So what is contract of indemnity? First we have to understand the simple meaning of indemnity, that is security against loss or to make good the loss or to compensate the party who has suffered some loss. Now, as per section 124 of Indian Contract Act 1872, contract of indemnity is a contract by which one party promises to save the other from loss caused to him by the conduct of the promisor himself or by conduct of any other person. Let us repeat the definition. So, a contract by which one party promises to save the other from loss caused to him by the conduct of the promisor himself or by the conduct of any other person. Now, what are the parties to this indemnity? The parties are indemnifier and indemnified, also called indemnity holder. Who is indemnifier? The person who promises to indemnify or save the other party from loss. And who is indemnified? The person who is promised to be saved against the loss. Now, let us read the example 3 as it is important. There is a person X who is a shareholder of a company and he lost his share certificate. He applied for the duplicate. The company agreed to issue the same on the term that X will compensate the company against the loss where any holder produces the original certificate. Here, there is a contract of indemnity between X and the company. Okay, so now let us understand what are the mode of contract of indemnity. So basically, it can be express or implied. Now, a contract of indemnity is like any other contract and must fulfill all the essentials of a valid contract, which includes A. Offer and acceptance, B. Intention to create legal obligation, C. Consideration, D. Competency to contract, E. Free consent, F. Lawful object, G. The agreement must not be expressly declared to be void. Example, an agreement in restraint of trade or marriage, etc. H. The terms of agreement must not be vague or uncertain. I. The agreement must be capable of performance. An agreement to do an impossible act is void. J. Legal formalities. So basically a question can be framed on the essentials of a valid contract in contract of indemnity. So they are offer and acceptance, intention to create legal obligation, consideration, competency to contract, free consent, lawful object, agreement must be expressly declared to be void, terms of agreement must not be vague or uncertain, agreement must be capable of performance, and legal formalities. Let us have a look on the example 5. A asks B to beat C, promising to indemnify him against the consequences. The promise of A cannot be enforced. Suppose B beats C and is fined rupees 1000, B cannot claim this amount from A because the object of the agreement is unlawful. Okay, now a contract of fire insurance or marine insurance is always a contract of indemnity, but there is no contract of indemnity in case of contract of life insurance. So this is very important question, can be asked in MCQs. Now, right of indemnity holder, which is very important. So there are basically three rights of indemnity holder. Number one, damages. Number two, cost. And number three, sum. All sums. Okay, so let us go ahead. Now the next topic we have is contract of guarantee. Before that, let us have a question, that is, when does the liability of an indemnifier commences? The liability of an indemnifier commences as soon as the liability of the indemnity holder becomes absolute and certain. Now let us start with the contract of guarantee. So basically, contract of guarantee is a contract of guarantee is a contract to perform the promise made or discharge the liability of a third person in case of its default. Let us repeat. A contract of guarantee is a contract to perform the promise made or discharge the liability of a third person in case of his default. So basically there are three parties to contract of guarantee. First, surety. Second, principal debtor. Third, creditor. Let us read about surety. Surety is a person who gives a guarantee. Okay, now who is a principal debtor? Person in respect of whose default the guarantee is given. And creditor, person to whom the guarantee is given. Now let us have an example on guarantee, where A obtains housing loan from LIC Housing, and if B promises to pay LIC Housing in the event of A failing to repay it, is a contract of guarantee. So this is a very simple example. Now it is clear that a contract of guarantee is a tripartite agreement between principal debtor, creditor and surety. There are in effect three contracts. So the first is a principal contract between principal debtor and creditor. Second is a secondary contract between creditor and surety. And third is an implied contract between surety and the principal debtor, whereby the principal debtor is under an obligation to indemnify the surety if the surety is made to pay or perform. Now, the right of surety is not affected by the fact that the creditor has refused to sue the principal debtor or that he has not demanded the sum due from him. It means that directly from surety, the creditor can demand the money or the thing which has been guaranteed. Now, contract of guarantee, the same thing we can just see here. Contract of guarantee is a tripartite agreement that are having three sort of contracts. The first is principal contract, second is secondary contract, and the third is implied contract. Principal contract is between principal debtor and creditor, secondary is between creditor and surety, and the implied is between surety and the principal debtor. Now, we are on the essential features of guarantee. There are basically 6 essential features of principle of guarantee. The first is principal debt. The principal debt, it means the purpose of a guarantee being to secure the payment of a debt. The existence of recoverable debt is necessary. Now, the second is condition. Like every other contract, a contract of guarantee should be supported by some consideration. But a guarantee without consideration is void, but there is no need of direct consideration between the surety and the creditor. Then we have, as per section 127, consideration received by the principal debtor is sufficient consideration to the surety for giving the guarantee, but past consideration is no consideration for the contract of guarantee. Even if the principal debtor is incompetent to contract, the guarantee is valid, but if surety is incompetent to contract, the guarantee is void. It means, for example, if principal debtor is a minor, this means it can be a minor and the thing can be carried on, but if surety is a minor, then it is void. Now, in the simple help with the diagram, we can learn any promise made, anything done, or for the benefit of principal debtor, then we have the consideration of for guarantee. Now, we have existence of liability. There must be existing liability or a promise whose performance is guaranteed. Then we have no misrepresentation or concealment. Any guarantee which has been obtained by the means of misrepresentation made by creditor or with his knowledge and assent concerning a material part of the transaction is invalid. Any guarantee which the creditor has obtained by means of keeping silence as to material circumstances is invalid. Let us go through the example number 13. A engages B as clerk to collect money for him. B fails to account for some of his receipt, and A in consequence calls upon him to furnish the security for his duly accounting. C gives his guarantee for B's duly accounting. A does not acquaint C with his previous conduct. B afterwards make default, then the guarantee here will be invalid. Now we have writing not necessary. Expressly declares that a guarantee may be either oral or written. Then we have joining of the other co-sureties, where a person gives a guarantee upon a contract that creditor shall not act upon it until another person has joined in it as a co-surety. The guarantee is not valid if that other person does not join. It means it is very necessary that co-surety join as per the terms if it is provided. So the essential features of guarantee are: number 1, principal debt; 2, consideration; 3, liabilities existent; number 4, no misrepresentation or concealment; 5, writing not necessary; and 6 is joining of the other co-sureties. Now next topic is types of guarantee, which is very simple. We have two types of guarantees. The first is specific guarantee and the second is continuing guarantee. What is specific guarantee? A guarantee which extends to a single debt or specific transaction. The surety's liability comes to an end when the guaranteed debt is duly discharged or the promise is duly performed. Now we have continuing guarantee, which means a guarantee which extends to a series of transactions is called a continuing guarantee. Now let us try to learn the distinction between contract of indemnity and a contract of guarantee. So basically we have 7 points of difference for which I have make a shortcut as NCLT square PR. So what is N? The first is number of party or parties to contract. There are only two parties, namely the indemnifier, that is promisor, and the indemnified, that is promisee. In contract of guarantee there are three parties. The first is creditor, second is principal debtor, and third is surety. The second N is nature of liability. So sorry, it is L here, so let us skip the shortcut, we can make it later. So nature of liability: the liability of the indemnifier is primary and unconditional, but in the contract of guarantee the liability of surety is secondary and conditional, as the primary liability is that of principal debtor. Now time of liability: the liability of the indemnifier arises only on the happening of a contingency. The liability arises in contract of guarantee, the liability arises only on the non-performance of an existing promise or non-payment of an existing debt. Now time to act: the indemnifier need not act at the request of indemnity holder. In guarantee, the surety acts at the request of principal debtor. Now right to sue third party: in indemnity, indemnifier cannot sue a third party for loss in his own name, as there is no privity of contract. Such a right would arise only if there is an assignment in his favor. Now in guarantee, surety can proceed against principal debtor in his own right, because he gets all the right of a creditor after discharging the debts. Now purpose: reimbursement of loss is the purpose in indemnity, whereas in guarantee for the security of the creditor. Next point is competency to contract. Or in indemnity, all parties must be competent to contract, whereas in guarantee, where a minor is a principal debtor, the contract is still valid. That we read before as well. Now our next topic is nature and extent of surety's liability. So basically the term coextensive with that of the principal debtor means that surety is liable for what the principal debtor is liable. However, the liability of surety may be less than that of principal debtor by an express contract to that effect. The second point is liability of surety arises only on default by principal debtor. But as soon as principal debtor defaults, the liability of surety begins and runs coextensive with the liability of the principal debtor. Okay. Now next point is where a debtor cannot be held liable on account of any defect in the document, the liability of surety also ceases. The fourth point is a creditor may choose to proceed against a surety first unless there is an agreement to the contrary. Now we have our another topic, that is liability of two persons primarily liable, not affected by arrangement between them, that one shall be surety on others default. So basically in this, for example, we have A, B and C, three parties, and C and A have the relation as creditor and principal debtor respectively, and A and B have another contract that is let us call as C2, and A and C's contract is C1. B is also a surety for A. Now the contract 2 cannot make I can say contract 2 cannot give effect on contract 1. The same thing has been written over here. So the liability of each of such two persons to the third person under the first contract is not affected by the existence of the second contract, although such third person may have been aware of its existence. Now very important topic, that is discharge of surety. So here we can see the modes of discharge of surety. The first is by revocation, second is conduct of creditor, and the third is invalidation of contract of guarantee. Let us start with the first one, that is revocation of contract of guarantee. In this we have three things: notice, second is surety's death, and third is novation. So the first one, that is contract revocation of the contract of guarantee. In it we have the first one as notice. The continuing guarantee may at any time be revoked by the surety as to future transaction by notice to the creditors. A specific guarantee can be revoked only if liability to the principal debtor has not accrued. Now let us read this important example 22. A guaranteed to B to the extent of rupees 1 lakh that C shall pay all the bills that B shall draw upon him. B draws the bill upon C. C accepts the bill. A gives notice of revocation after the bill is drawn and accepted. C dishonors the bill. At maturity, A is liable upon his guarantee. Now the second is by surety's death. In the absence of any contract to the contrary, the death of surety operates a revocation of continuing guarantee as to future transactions taking place after the death of surety. However, the surety's estate remains liable for the past transactions which have already taken place before the death of surety. Now the last is novation. So basically the surety under original contract is discharged if a fresh contract is entered into either between same parties or between other parties, the consideration being the mutual discharge of the old contract. Now we have by conduct of the creditor. In this we have basically four things. The first one, variance in terms. Second is discharge or release of principal debtor. Third is the compounding, and the fourth is remedy. Let us go through each one by one. So the first is by variance in terms of contract. Where there is any variance in terms of contract between principal debtor and creditor without surety's consent, it would discharge the surety in respect of all the transactions between taking place subsequent to such variance. So there are many questions formed on this. Here we have a very famous case law between that is MS Anirudhan versus Thomco's Bank Limited AIR 1963 SC 746. It says variation which is not substantial or material or which is beneficial to the surety will not discharge him of his liability. So the surety, yeah. So the conclusion that is held in this case law is on default by the principal debtor, the court held the surety's liability was not discharged as the alteration was beneficial to him and not substantial. Now the second is release or discharge of principal debtor. The surety is discharged if the creditor enters into a fresh or new contract with principal debtor by which the principal debtor is released, or does any act or omission the legal consequence of which is discharge of the principal debtor. Let us read the important example 29. A contract with B for a fixed price to build a house for B within a stipulated time, B supplying the necessary timber. C guarantees A's performance of contract. B omits to supply the timber. C discharged from his suretyship. Now the third way is when creditor compounds with, gives time to, or agrees not to sue principal debtor. Okay, a contract between the creditor and the principal debtor by which the creditor makes a composition with or promises to give time to or promises not to sue the principal debtor discharges the surety unless the surety assents to such contract. Here we have three things in it: the composition, the promise to give time, and the promise not to sue. The important question comes on cases where surety not discharged. First, surety not discharged when agreement made with third person to give time to principal debtor. The second is creditor's forbearance to sue does not discharge surety. The example is B owes to C a debt guaranteed by A. The debt becomes payable. C does not sue B for a year after the debt has become payable. A is not discharged from his suretyship. The fourth way was the creditor's act or omission impairing surety's eventual remedy. The first point is if the creditor does any act which is inconsistent with the rights of the surety, or omits to do any act which his duty to the surety requires him to do so, and the third, the eventually remedy of the surety himself against the principal debtor is thereby impaired. The surety is discharged. Now there is a case in which we can see that there is the party A, B, and C. Here B and C makes a contract, and for example B is the bank and C has put his stock as the asset as a security. Now if creditor, that is bank, has lost the stock, then the principal debtor or surety both are free till that amount that bank has lost that stocks. So for example 20 crore stocks are lost. Now 80 crore is the amount which principal debtor and surety has to pay. Now the third way of discharging is by the invalidation of contract of guarantee. In this we have three ways. First, misrepresentation, second, concealment, and third is the co-surety. So under invalidation and in it misrepresentation, that is guarantee obtained by misrepresentation is invalid. Any guarantee which has been obtained by means of misrepresentation made by the creditor or with his knowledge and assent concerning a material part of the transaction is invalid. Second, by concealment, invalid. Any guarantee which the creditor has obtained by means of keeping silence as to material circumstances is invalid. Now, the third is guarantee on contract that creditor shall not act on it until court surety joins, where a person gives a guarantee upon the contract that the creditor shall not act upon it until another person has joined in it as co-surety. The guarantee is not valid if the other person does not join. Now, our one of the last topic, but not the least, is right of surety. The surety enjoys the following rights against the creditor: the rights against creditor, right against principal debtor, and rights against co-surety. Let us start with right against the principal debtor. So basically we have two rights, that is right of subrogation and implied promise to indemnify surety. So the first is right of subrogation, where a guaranteed debt has become due on or default of the principal debtor to perform a guaranteed duty has taken place. The surety upon payment or performance of all that he is liable for is invested with all the rights which the creditor had against the principal debtor. The right is known as right of subrogation, which means that on payment of the guaranteed debt or performance of the guaranteed duty, the surety steps into the shoes of the creditor. Now, implied promise to indemnify surety. In every contract of guarantee, there is an implied promise by the principal debtor to indemnify the surety. The surety is entitled to recover from the principal debtor whatever sum he has rightfully paid under the guarantee, but not the sums which he paid wrongfully. Now, right against the creditor. So basically there are three rights which are against the creditor available to surety. First, surety's right to benefit of creditor's security. Second, right to set off. And third, right to share reduction. The first, surety's right to benefit of creditor's security. A surety is entitled to the benefit of every security which the creditor has against the principal debtor at the time when the contract of suretyship is entered into, whether the surety knows of the existence of such security or not. If the creditor loses or without consent of surety parts with such security, the surety is discharged to the extent of the value of the security. Next is right to set off. If the creditor sues the surety for the payment of principal debtor's liability, the surety may have the benefit of set off, if any, that the principal debtor had against the creditor. Next is right to share reduction. The surety has right to claim the proportionate reduction in his liability if the principal debtor becomes insolvent. Now, right against co-sureties. So, what is co-surety? When the same debt or duty is guaranteed by two or more persons, then it is known as co-sureties. Now, right against co-sureties are two. The first one is co-surety is liable to contribute equally, and the second one is liability of co-surety bound in different sums. So the first one is co-surety is liable to contribute equally. Equality of burden is the basis of co-suretyship. So next one is liability of co-surety is bound in different sums. For example, if the limit has been set by the co-sureties, then they are liable to pay till that only. So that's all for today's video and learning from the module itself. We will continue the series. Thank you for watching.